Hi everyone, today we're going to be talking about VAWA protections, legal options for immigrant survivors of abuse. My name is Ruby Powers and I'm board certified immigration attorney with Powers Law Group. We have a full service immigration law firm, 16 years old, and today we're going to talk about VAWA. So what is it? Well, it allows self-petitioning for legal status without the abuser's knowledge. And even though the word, it says women in it, it's actually applies to women, men, all individuals, regardless of gender. It applies to spouses, children, and parents of U.S. citizens or permanent residents, and it covers battery and extreme cruelty, including psychological, emotional, financial, and many different aspects of abuse. Provides confidentiality protections to prevent retaliation, and it can create a pathway to lawful status. So for spouses, would be abused by a U.S. citizen or legal permanent resident spouse, includes if children were abused. Children for unmarried under 21 abused by U.S. citizen or legal permanent resident, and parents abused by U.S. citizen child, son or daughter, age 20 plus, 21st, 21 or up, because a child is um, because but the victims can apply even after a divorce, death, or loss of abuser status. If linked to the abuse, there can be different requirements depending on the particular situation. And you have to prove the good moral character and residence with the abuser. If there was a spouse relationship and it has to be filed within 2 years of after the divorce, or sooner. You can also still be married, and 2 years within the divorce, the death, or the loss of status. So if we're talking about spouses, we're talking about having a valid marriage, the U.S. citizen or legal permanent resident entered into good faith, that battery or extreme cruelty, that you show evidence with police reports, medical records, affidavits, statements, right? Residency with a spouse in the United States, and the good moral character proof, which would show that the immigrant who's applying has good moral character. Victims may include children under 21 on petitions. The divorce during the process does not bar eligibility if abuse is proven. However, remarriage before the approval of the process results in a denial. So remarriage after does not cancel the status. But if if you get remarried before the VAWA approval, then case will be denied. For children that be under 21 and unmarried at the filing, but it is up to 25 if abuse caused the delay. Suffer battery or extreme cruelty by a U.S. citizen or legal permanent resident, lived in with abusive parent in the United States, show good moral character. And the children of VAWA petitioners may be included as derivatives. Application protect that family unity while ensuring the abuse survivors have a path to lawful immigration status. For parents, we're talking about abused by a son or daughter who's 21 and up, who's a citizen. The child lost or renounced the decision to do abuse incident, the child died within 2 years of the filing. The battery and cruelty evidence, the documentation like police reports, affidavits, psychological reports, residence with that child, and good moral character of the immigrant. The application process starts with the I-360 with that evidence. It's going to be sent to USCIS Civil Service Center. You'll receive a prima facie receipt and then a prima facie determination, which is valid for 150 days. And USCIS may grant a deferred action while the petition is pending. Some people apply for the I-360 and the 45 together. Some people are only eligible for the I-360. Sometimes the I-360 has to be filed first because the visa is not available. For example, if it was a legal permanent resident is the abuser, and according to the visa bulletin, the visa is not available. So those are things to consider. Also, some people are not eligible to file for the adjustment of status if they're permanently barred, have some other inadmissibility that prevents them from being eligible. So the benefits of VAWA would be the work authorization, ability potentially to apply for legal permanent residency, protection from deportation through the deferred action, and access to certain public benefits. They may later apply for citizenship, meeting the requirements if you get the legal permanent residency. So if you'd say you file the I-360, the visa's available, you could file it concurrently with the I-45, their adjustment of status, or do two steps. For the green card to be approved, you need to have had the visa available, the I-45 filed and be in the US, have the visa available and be admissible. And then these are things consider are, how many times did you enter? Did you enter and leave? Do you have a permanent bar? If you do, you're not eligible for this unless the abuse of the situation that caused you to apply for VAWA is the reason why you have the permanent bar. So that's like a little known fact, but you do need to be screened for inadmissibilities, entries and exits and things like that. There is something called VAWA cancellation removal. That's in immigration court, only in immigration court. You have to show 3 years of continuous presence, the battery, extreme cruelty by the U.S. citizen or legal permanent resident, spouse, or parent, demonstrate that good moral character, and show extreme hardship. Very, very similar, but it's just different, a little bit different requirements. And the approval cancels removal and grants the permanent residency. Now, it is important to note there's confidentiality, and it restricts that disclosure to victim details to third parties, which is great to know. And that they should be able, the immigrant can pursue this without fear of retaliation. Things to consider, not missing a deadline, that 2-year limit is really important to know. Making sure you submit enough proof of the abuse, not remarrying before the approval of the VAWA petition. If you fail to inform USCIS of address changes, these cases can take a long time, so you might miss something that you need. And if you don't rely on someone trustworthy, so make sure you check reviews, make sure you've done your research, you have evaluated their bar, and they have, and those are the things you need to look at. If something sounds too good to be true, it probably is. So be smart about that. So make sure that you file timely and accurately. Everything that you say is true, not embellished or incorrect or wrong, because this is not that there's a lot of scrutiny going on right now. Very likely you would have an interview for VAWA and adjustment of status for VAWA, and be aware of having a copy of what you're filing. Right now, there's been some changes. It's important to make sure you have that good moral character and you have evidence. There have been some concerns about filings with attorneys embellishing the story and not evaluating for inadmissibility issues. So be aware of those types of things. But it's important to gather evidence, consult a reputable immigration attorney, seek counseling and support, and know that this is a program that does exist. We also have information about domestic violence hotline and other legal aid organizations out there. If you can always reach us at 713-589-2085. Again, my name is Ruby Powers. You can find us on Facebook, X, Blue Sky, Instagram, TikTok, and we actually have a newsletter out in English and Spanish every other week. So this was this week's the VAWA protections, and we'll have some coming soon, E2 visas, and some other updates, including about the ICE check-ins. Thanks so much for watching. This is an important topic. Please feel free to share with someone else. We have presented this also in Spanish as well. Thank you, and feel free to stay in touch with us. Have a good day.